The NSL, or the National Security Law, is a document like this, 60 pages in the English version, and it is a law which concerns the national security of Hong Kong and China. And it's a law that was introduced into our domestic law via our basic law by the central government. The NSL is controversial for three basic reasons. First, the way it was introduced into our law. Second, because of some of the things it says and doesn't say. And lastly, because of its very structure, which is problematic from a rule of law perspective. What it says is it creates a bunch of offences. Secession, splitting away from China. Subversion, which is undermining or overthrowing the government. Terrorism, we all know what terrorism is. And the final one it introduces is collusion with foreign forces or interests undermining the national security of China. What it doesn't say is it doesn't provide very important defences to these charges which are available in the common law version of them, which exist in our law in Hong Kong and have done for very many years. And it's also expressed in very, very vague language, so it lacks precision, and that is a problem. The law itself embraces the rule of law and promises that the rule of law will be used in all charges and penalties and all proceedings that are conducted under the NSL, which is great. The problem is that the final interpreter of the meaning of that law is the same body, i.e. the Chinese Parliament, who wrote the law. So to have the final arbiter of the law as its author, or the other way around, is something that we common lawyers just do not understand in the context of the rule of law. If we have these repeated interventions by China in our law, people will not see Hong Kong as a distinct international financial centre that is different from the rest of China, but just another Chinese city. At a point when the cultures of Hong Kong and the culture of the PRC are certainly not one, I think there's a real risk that the rest of the world, and maybe even Hong Kong, will see the formula here as not one country, two systems, but one system, two countries. And that would be a disaster for Hong Kong. It would be a disaster for the PRC. It would be a disaster for our reputation as an IFC. And that was something none of us want. Moving closer to the concerns that people who have their trusts and companies administered in Hong Kong, I can say that the immediate impact is negligible. The courts are still here, they're still competent, they're still honest, they're still deciding their cases without any interference whatsoever from the NSL, from the Hong Kong government, from the Chinese government. None of the corporate laws are going to be changed, none of the trust laws are going to be changed. There's nothing at all in that law which will impact on trust administration in Hong Kong at all. So what people should be doing in response to these developments is two things. First, don't panic into taking precipitous actions which could be costly and unnecessary. And second, if people do have qualms about these issues, they should put into place now an exit strategy which can be cleanly and quickly executed in the future should the need arise. So, if you want to know more about what I've been saying today, you can look at the article that I've written, and it's published on my website, which is ahernlawyers.hk. And if you want to know more about the specifics of the NSL itself, you can visit haldanes.com's website, and there's a very excellent piece there for you to drill down. So thank you very much for your attention.